So I can go ahead and take, oh, Sharon looks like is in, I'm going to promote her. Maybe she didn't get the invitation. Great. Let's see. Okay, Sharon, it looks like you're here now. I apologize if you didn't get the invitation from Zoom, but I'm glad to know that you're here. I will go ahead and take the roll. Bashan?
Present.
Felmuth?
Here.
Kirkmeyer?
Here.
And Spiro?
Here.
Okay, we're fully present and we have a quorum. And I was just going to start by, well, first we should see if we have any public comment. I see we have a number of attendees. If anybody wants to make comment, you can use the function to raise your hand in the Zoom meeting. I'll give a little bit of time to allow people to do that. Okay, it looks like we don't have any interest in public comment. So I was just going to, I just have one slide that's been prepared. And that is to, hold on a second. Just wanted to bring up, these were the issues that were identified at the meeting on October 29th, excuse me. So the three things that we were going to take up, and we have done, Leah has done some work on developing what the cost of the program would be. And then there was a couple of other issues that came up, was whether we should include paraprofessionals on panels if the determination is made to use hearing panels instead of state bar court. And also there was a discussion of including these non-disciplinary remedies, the citation and fine in lieu of discipline, whether those should be part of the public record. Were there any other topics that people recall needed to be discussed further at today's meeting?
Linda, this is Kim. I thought there were some questions around unlicensed activity and how those complaints or how those cases would go through the process as well. Okay. And I think we had briefly talked about it when we met, right, Ira? But we didn't, we hadn't like thoroughly fleshed that out.
I don't remember for sure. But do you mean unlicensed activity by the licensees? Is that it?
Well, like if there is a complaint that came in saying there was an unlicensed paraprofessional, what would happen with that?
Oh, that somebody was doing paraprofessional work and they weren't licensed to do it.
Right.
But we can add that to the list. I mean, I don't think it's so different.
I think the response to that is that the State Bar intake unit and investigators routinely refer on UPL, unauthorized practice of law, to district attorneys.
Yeah, I remember now. I don't think that our panels would have any jurisdiction over that. It's yeah, you agree? Okay.
Yeah, no, I just know there was a question like, how would these be processed? But I agree completely with Julie. That's how it should go. They would have to go through the DA. I'm assuming that's how it happens. But
yeah,
I know that I'm new to the subcommittee, but has this group spoken to DAs that prosecute these cases on a regular basis? Because my understanding is that they are overflowing with cases, and I would just want to hear it from their side. And just consider other things like criminal remedies for those types of cases that have willful conduct.
This group has not. We have talked to DAs extensively because of the unauthorized practice of law on the attorney side, which is quite significant. In addition to referral to the DA, though, I do want to clarify the State Bar does have other remedies. State Bar can assume jurisdiction over a practice. Namely, so, and the State Bar does pursue that remedy on the attorney side. So presumably the same structure would be implemented for paraprofessionals.
Well, Leah, when the state bar does that, they have jurisdiction because the person involved is a lawyer, a member of the state bar. Am I
No.
right or no? Oh,
No,
really?
they're separate statutory authority. The state bar just doesn't have an authority to pursue any criminal sanction. The
Oh.
state bar can also pursue a civil sanction, a civil fine. So the state bar does have authority to do some things in that area. I just want to clarify that. It's not simply a referral to a DA. But I think we could certainly have someone from our UPL unit come to talk to you at your next meeting. And we could also invite a DA who does. I know there's like a very active partnership, for example, with the San Diego County DA's office.
Leah, one thing for like DCA boards and bureaus for unlicensed activity, if you do get cite and fine authority, some of the boards and bureaus actually start out, if depending on what the violation is, at that level too, to where they would issue a citation and fine for the unlicensed activity. Obviously, that individual may not pay that, but then you would refer them over to the franchise tax board for payment. But at least it gives one warning that, hey, you need to be licensed to do what you're doing before you get, then that helps your case when you do take it to a DA. So that just something to consider as well.
Oh, well, I had thought there was no possibility the group or, the eventual product of our work would have jurisdiction over that, but it sure looks like they could if there were the right, maybe it takes a statute, sounds like it does, to give the group the power. So I'd be in favor of that, especially since we're getting so many, we get very strong comments from the public about unlicensed people right now in immigration and other fields.
Okay, well, let's add unauthorized practice of law to the list, Linda, and then maybe we can figure out what we need to do to further explore that.
Oh, Leah, I have a question. Since paraprofessional work, the way we're conceiving of it now, is the practice of law, wouldn't the state bar already have jurisdiction over somebody doing paraprofessional work?
Unlicensed, yeah, I don't know. So I think one thing we need to do is figure out, like, how would the existing the regulatory scheme need to be modified, if at all, to give the state bar and DAs jurisdiction over this new class of unauthorized licensee. So I don't know the answer. I would assume that the state bar already has jurisdiction. There are already people that would be engaging in UPL.
Yeah.
They're not a licensed paraprofessional. I don't think, I think perhaps it could be absorbed in the existing statutory scheme.
Sure sounds like it too. I'd love to see citations to the laws that give the bar the power to do that. To look at the unlicensed, a UPL, I mean.
Okay. Linda, maybe we can provide the annual discipline report, which is on the state bar website, does have a UPL appendix or addendum, and I believe even this year it continues to lay out the various statutory bases for authority. So that's on the state bar website. We can send the link, but that's probably the easiest place to access various boards.
It's interesting thought, because what we're doing here is we're actually just creating not a defense but an exception. So anything that there's nothing new. There's no new unauthorized practice of law that would be created by anything we're doing it, because if they're practicing law illegally now, they would be, whether or not we have a paraprofessional program unless they're licensed by the paraprofessional program. They're doing what they're allowed to.
Yeah,
No.
I got it. That makes sense.
Okay. Anything else that we need to add to our list?
Could I just ask a question? Has this group met since we all met on October, since the whole working group met on October 29?
No.
So both of those options are still in play. The options on your chart here, where you have a 3-person hearing panel.
Mm-hmm.
Okay.
Okay. So do you want to go to cost? Do you want to talk more conceptually about the options? Cost may be instructive. I might suggest we start there because it's interesting what we were able to pull together.
Sure.
Okay. Linda, can you pull that up? I just sent you the document right before the call. Are you working on that, Linda? I can't hear her. Linda?
Sorry, I am looking for it, and
Okay.
it's hard to do, like, manage my muting and looking for things. So yes.
Okay. So just to walk you through what I did here. It's obviously difficult to really figure out what workload might be. And I think that's important. So we started off with, can you close the things at the bottom? Okay. I started off just by looking at Ontario because it's the most well-established program that we have. That got really small, Linda. We're not seeing it anymore.
Sorry, I'm trying to manage several things on screens at one time, and I need to move things around so that I can see what I need to see. And then I will share that again. This is the joys of managing all this different technology. Okay, now can you see it?
Yeah.
Yes.
Okay. So Ontario is the most well-articulated program, and so I use their data to just try to come up with an estimated complaint rate, right? Because one of the important components of cost modeling is figuring out what we think the volume might be. So you can see from there, they've got a 12% complaint. You can't see it, but I can explain to you that in 2019, the Ontario program received 4,379 complaints about both attorneys and paralegals and other. And 12% of those complaints were with respect to paralegals. So that's 525. There's 9,470 licensed paralegals. So the complaint rate is 5.5%, 525 over 9,470. And then the next kind of piece of input information that I think is helpful is just to look at the current caseload levels and workload levels in our Office of the Chief Trial Counsel. So you can see we've got 49 cases per investigator, 42 cases per attorney. And those two numbers are the most important. This is not necessarily an ideal staffing level because the State Bar was not fully funded to achieve the caseload levels that it identified as ideal, but this is the current staffing level. So then you go down and I began to estimate the cost for a panel model. So if you can scroll down a little bit, Linda. So here I start with OCTC, intake and investigation and charging. And this part of the system you've designed would apply regardless of whether we use State Bar Court or not, right? Because OCTC is going to do intake and it'll do charging. And I said, this is arbitrary at this point, but in a way, I think you've got to start somewhere. So it's at 0.5 of an attorney FTE, 5% of an admin, and 5% supervision. I don't have any investigators in this model because I believe the caseload is going to be so small that an attorney could do investigation and charging on this caseload. These costs I have here are fully loaded, meaning salaries and benefit costs. So at what I estimated, that's sufficient to handle about 20 cases a year. If you look at our current OCTC staffing level, which is about 40 cases. And when I say a year, that's probably a little inaccurate. It assumes a case sits with someone for a full year, but that's 20 cases at any one time. So I should clarify that for an attorney working in this system. And using the Ontario complaint rate of 5.5%, that would translate to about 360 licensees. So if you had about 300 to 400 licensees, you could expect you're going to get about 20 complaints. So this is how I back into what the number is. And of course, we would not expect to have 300 to 400 licensees for some time, but eventually we'd want to have many more than that. But this is just the basic beginnings of a methodology. And then for our adjudicators for hearing and appeal, I put 0.25% for the hearing level, 0.125% for appeal. I kept an admin and supervision at those levels the same. The reason it went down from 0.25 to 0.125 is I don't believe, not that many cases are going to go to the appellate level. So you begin to see an estimated cost without the State Bar Court, the panel model. Those total to $210,000. This is, I think, good for a sticky pad calculation. We really have no idea what the volume is going to be, but it gives us a place to start. And if you scroll down on the next page, start looking at it with the State Bar Court. So here, the only thing I changed in the intake section is I think I changed actually supervision and admin, and maybe I shouldn't have. I intended to change the attorney from 0.5 to 0.65. And the reason that I did that is that if these cases are going to go to State Bar Court, which is much more formal and has many procedural rules, as opposed to a hearing process, which we get to design and develop, I'm going to assume that it's going to take more attorney time. So I put 0.65 for that same 20 cases. The rest of this should be the same, although it looks like I may have modified admin and supervision. Again, I didn't intend to. State Bar Court costs are provided for you here. So you can see that this is very significant. So we've provided 2017, 2018 direct costs and indirect costs for State Bar Court, and then the number of cases cleared in the year. And so you can see that the cost per case ranges for between 2017 and 2018, $19,000 to $22,000 per case. So I just used 20,000. I multiplied that by 20 cases, and you get $400,000 for State Bar Court piece, not including any of the OCTC costs. Now, the reality is, right, our systems should be able to absorb this very incremental new workload that's going to grow over time. However, as I think we've pointed out on a number of occasions, there are political reasons and then at some point, actual volume reasons why we will have to discretely charge out and cost out and allocate out costs associated with the paraprofessional program. So, we might like to think that State Bar Court or OCTC could just absorb 20 cases with no new funding. And, in the grand scheme of things, maybe they could. But politically, I don't know that we will be able to do that. And certainly when you look at the cost per case in State Bar Court here, you can see that it is so significant that simple cost absorption is probably not viable. So I'll open up to questions. Hopefully that was pretty clear.
I want to, it's clear in my mind about this, but just so everybody maybe in the public or who's listening, the political issue, Leah, correct me if I'm wrong, is about the cost, is that members of the state bar, lawyers, California lawyers who are paying their dues would object, many do object to paying to their dues going towards this paraprofessional program. And even though there'll be a small number of paraprofessional cases in the state bar court, still, if you divide it all up per case, there'll be some expense. They would argue that the lawyers' dues are paying for some expense of disciplining paraprofessionals. If I got that right, it wasn't well said, but.
Yeah, I think that there'll be a concern that attorney licensing fees are subsidizing the program. I will say that because the state bar statutory mission does include increasing access to legal services, and this program is designed to do just that, I think there's certainly a Keller type of, legal use of state bar fees kind of argument to support quote unquote subsidization of the program by licensing fees, because it is a program to increase access to legal services. But that just may not be politically feasible, and it may not be the way that we want. We may not want to assume out of the gate that is how this program is going to be funded. So I think it's important to think about it as discretely funded with no subsidy by the attorney discipline system. And this is the beginnings of cost estimation. And part of what I'd love to get, especially from you, Kim, are all the things that we should add, look at how you all do this when you start a brand new program in terms of assumptions that you're using. So I don't know if that answers it, Ira, but that is, yes, I think you got the politics right there.
Leah, I had a question. So the way I understand the math is that this is budgeting out the intake and investigation, and I mean the whole procedure for cases where there's charges.
Mm-hmm.
How do you think about, obviously much cheaper, the mini cases that either at intake or after some investigation there's a decision not to proceed?
This is really rough. So it's assuming that 20 is going to be a mix. Basically, like you're gonna get 5.5%. You're gonna have this complaint rate, and you're gonna get some that nothing happens with, they close immediately, and some that don't.
Oh, okay. Oh,
yeah.
So this 20 is a mix. I thought this 20 was okay. So
it's just a mix because I don't have the data. I don't have it readily available in Ontario. Like of the 525 complaints that were filed against paralegals, at which stage did they close? And we know in our system that the vast majority of cases close at intake. So, but the intake process itself does require time,
right,
attorney time for review. And then those cases that go all the way up are going to be much more expensive. So it's like
got it.
It's really truly an estimate. I don't think it is an underestimate. It's probably an overestimate under both scenarios, but it's reasonable that it's not, about a half-time attorney is going to be working on this.
Thank you.
This is Sharon. I appreciate that this is like a starting point, and we do need a starting point to begin to look at costs. What about spillover costs to other systems? As UPL cases go up to district attorneys, et cetera. Was that considered in these numbers?
No. And the other costs, right, that are spillover, not to different entities, but presumably you might have, I don't know, licensees on probation. That's a state bar court cost. I don't know if we'd send licensees through the LAP program. We haven't talked about whether they would pay us an LAP type of fee. And then there is client security fund type of expenses, but we are dealing with those costs in the regulation committee. But just on the discipline side, there's also mandatory fee arbitration, which I think we also need to add to the list, Linda, because there's been some discussion about whether there would be mandatory fee arbitration for these paraprofessionals. That's another cost. So there are costs outside of just the pure investigation and prosecution of complaints.
Sharon just mentioned something that rang a bell for me about UPL. Correct me if I'm wrong, Sharon, about UPL costs going up or UPL cases going up. And then it occurred to me, wouldn't they go down? In other words, if when the paraprofessional program is initiated, it starts, it wouldn't, I don't see why it would cause instances of UPL to increase. In fact, it might cause them to decrease because some people who are engaging in UPL would then be able to do the same thing, but lawfully, because they could become paraprofessionals. But I don't see why anybody who's engaging in UPL would, why more people would be engaging in UPL at this, when the paraprofessional program starts.
That's a good question, Ira, and I wonder if that assumption is correct. I could easily argue that maybe numbers will be up because you are going to have a whole host of folks who don't want to jump through the hoops of getting licensed, who practice these behaviors, but without the license. But we're not sure what it's going to look like.
So Leah, just to kind of answer your question about assumptions and everything on our side, you know, a lot of times we're looking at it in two different worlds. It depends on where that new licensee type is going to go, whether it would be like going under one of our current boards or whether it was a new standalone board. Because when you're looking at a new standalone board, what sometimes may have to happen is for us is that those entities would have to get a general fund loan to start up that program. But we'd be doing the same thing, like looking at assumptions of how many cases do we think we would need? How are those cases going to be processed so we can identify the salaries and wages of those individuals we would need to hire and put that board together. How many licensees do we think we have in the first year, and trying to build that license application and initial licensing fee to pay for those items. And then over time, they would then have to repay that general fund loan. So it's kind of like you almost have to have the process that it's going to follow so you can build that. See, because you're talking about it coming out of like the attorneys, and even if those board, even if it was a new license type going into another board, you'd still want them to pay for, you know, their profession and their licensure and a discipline process. So it could be maybe within that board, they're looking at a loan over to that special fund. But that's kind of how we look at it. Does that answer your question?
It does. And I think that the difference here is there might still be a loan. I'm really interested in the loan structure. It could be a loan from the state bar's general fund to the program instead of from the state general fund. So I think that certainly could be contemplated. I do want us to consider, though, this question of whether or not the attorney licensing fee can't subsidize the program at all. Because as I said, it is a little bit different maybe than other licensing boards. Part of the statutory mission of the bar is to increase access to legal services. And the licensing fee does pay, for example, for our entire Office of Access and Inclusion and all of the work that they're doing. So I think, and maybe the way it's subsidized is a no interest loan. So that, there's no interest on the loan. So it's sort of, that's the subsidy. I don't know. I think it's just something we should consider. But it does make sense. And I think, again, these are very hypothetical scenarios. I don't think we should contemplate a model that's less than 0.5 of an FTE attorney even from the beginning, when it won't be 0.5 of an FTE attorney's time. But I just think it becomes so microscopic that it's not reasonable. So I don't know. This is what we have. I think it's a decent place to start, and then we can refine it as we go along.
Leah,
Mm-hmm.
it's Julie. I just want to make sure I understand what you've presented here. You've presented statistics indicating that the use of the panels that were on this chart that was distributed on October 29, the use of the panel model would cost the bar a total of $210,000 per year. And then if instead of using a panel, you use the state bar court for evidentiary hearings and appeals, the cost to the bar would be $571,750. Is that right?
That's what I presented. And again,
Okay.
It's a little difficult to get your head around conceptually because it doesn't seem right. And I want to acknowledge that it's assuming you're not just absorbing this work into your existing staffing levels, and it's taking the current cost per case in state bar court and multiplying it by this estimate of 20 cases. And,
Yeah.
and as Brady mentioned, maybe one immediate problem with this methodology is not all 20 cases are going to end up in state bar court. So for 20 that the OCTC might be grappling with, and this is probably a true correction that needs to be made right away, for the 20 that OCTC is going to grapple with, there will be a much smaller number that actually find themselves to state bar court. And we could use, I don't know which case closure rate we could use for attorney complaints, for UPL complaints, to estimate the percent that would actually go forward to state bar court. But if you get any more than a handful going forward to state bar court, that model becomes a lot more expensive.
And Leah, can I ask a follow-up question on Julie's? And that is, you were looking at it from the panel perspective, not from like a one staff adjudicator, right? In your first analysis?
Well, I do have a staff adjudicator. I just don't think it's a full-time job. So I have it at 0.25 for the hearing. So it's a staff person that obviously would be doing other things. Yeah, and that could be incorrect. Also not here are stipends for the other panel members.
And just so the new members can kind of understand Ira and I's thought process on the giving a stipend or something like that. We were talking about volunteers, and we were saying, if their volunteers are kind of rotating in, we kind of wanted consistency. So we wanted like a set group that would be the ones like over a certain time frame to look at those cases. So there would build consistency, and so they kind of have ownership of the process, rather than just a bunch of individuals, volunteers rotating through.
Right.
And I absolutely agree with that. And you need to consider the time frame that these panel members would serve, because you want them to build up some expertise in analyzing and deciding these kinds of cases. Volunteers doesn't work. My husband was the state bar discipline monitor back in the late 80s, and he took a system that involved volunteer attorney investigators on the local level, volunteer hearing examiners on the local level, and then they would take there was an 18-member review department that would review proposed decisions coming out of these volunteer hearing examiners. It was extremely inefficient. There was no guarantee that the investigators or the hearing examiners were trained. It was just not a good system at all. So having a set number of group composition be there for a while with staggered terms, if you want to call it that, is a unnecessary idea.
Was the inefficiency that related to the fact that they were volunteers and maybe they weren't as getting to the cases as quickly as they could, or was it the fact that they were not staggered?
I don't know that they were staggered at all. These jobs, these quote unquote jobs, and because it was volunteer, looked good on an attorney's resume to be called a bar hearing examiner. They weren't necessarily trained. There was no guarantee that they knew anything about the area of law that the accused attorney was practicing. They could be competitors or colleagues of that accused attorney, and there weren't very clear recusal, ethical requirements. It was just very inefficient. If you want to read about how and why it was inefficient, the California Supreme Court put out a decision in about 1988-ish, 87 or 88, called Maltaman, M-A-L-T-A-M-A-N versus State Bar. And the court at that time was spending 50% of its docket on attorney discipline cases because it did not trust the output of this disciplinary decision-making process. They were spending 50% of their time. They would review cases where the attorney didn't even appeal from the state bar courts, from the final decision of the state bar. And so they put out this Maltaman decision right as we were in the process of drafting legislation to completely overhaul the state bar's discipline decision-making process. And it was quite critical of that process. The court said, we're receiving cases where an attorney is being disciplined for something they weren't charged with in what was at that time called the notice of notice to show cause. That's what it was called then. It's now notice of disciplinary action. So the court said people are being disciplined for things they weren't charged with in the formal charging document. There is no evidence necessarily connecting up what they were charged with and what they were disciplined for. It was very, very critical of the whole decision-making process, which is why shifting it from this volunteer system to professionalized, we went from thousands of volunteer hearing examiners all over the state of California to a 6-member hearing panel in the state bar court. And those hearing judges were appointed, all of them at that time, by the California Supreme Court. We went from this 18-member volunteer review department, only 2 members of which would review any given disciplinary matter, to a 3-member review department consisting of 3 judges appointed by the California Supreme Court, and one of whom was a non-lawyer at that time. Now, changes have been made to this system since then. The legislature now gets to appoint some of the hearing judges. The non-attorney judge on the 3-member review department has been done away with. We disagreed with both of those proposals, but they were being made by John Burton at the time, and generally what John Burton wants, John Burton gets. And I think they were also stuck in a bill that was double joined to the state bar dues bill. So even the state bar was not in a real good position to oppose anything that was in either of those bills. But so what I'm trying to get at is that volunteers versus professionals, there's no question. Professionals need to be doing this. And professionals who don't have a bias need to be doing this. So, and that's where we were able to take the state bar, the structure and the decision-making process of the state bar's discipline system back in the late 80s. And as I mentioned, the Maltzman case, after the bar implemented the statute, which was called Senate Bill 1498, that we wrote in about 1988, maybe 89. The state bar then put out, the Supreme Court put out something called the finality rule. And the finality rule has two parts. The first part is if you are an aggrieved attorney and you don't like the final decision of the state bar court and you want us to review it, you have to appeal it to us. So that was new because the court had been reviewing all decisions coming out of the state bar court forever. And the second part is our decision to review your case is discretionary. And somebody challenged the constitutionality of that in a case called In Re Rose in the early 90s. And the court upheld the constitutionality of the finality rule. So the court is much more trusting of the bar, the output of the state bar court now than it ever was. And as a result, very few attorneys appeal their discipline to the Supreme Court compared to what it was before.
Well, it sounds like we have a lot to learn from that experience. One thing that you brought up that rang a bell was just how we train and educate these panelists. Was this something that was considered by this group before? Is what training they'll get?
No. We haven't gotten there. I think based on so this group recommended a panel model. We got feedback at the meeting about why not use the state bar court. There was also, a question about what is the value of having a licensed paraprofessional, a licensee, be part of the disciplinary process. So I think your threshold decision is, do you want to stick with the panel model? And then if so, we can work on, I think a next step would be what kind of training and what does this look like? But we certainly got some feedback about, well, just use state bar court. And there were, I think from the state bar side, we were saying that it's an expensive model. And I think you can see that. And it does up the ante. And I think it would be more expensive for the licensee to go through the state bar court versus a panel. But there's also the fact that in the state bar court model, there is no licensee, there's not a public member. It's a different kind of adjudicatory structure.
Mm-hmm.
Would it be possible for Linda to pull up the chart again for those visual learners like myself?
Yeah, I'm sure she can.
You mean the chart that was presented with the structure?
Yeah, with the structure.
Sure, I can do that.
While she's doing that, Ira, Kim, did anything change for you in terms of absorbing in state bar court or sticking with what had been proposed?
Not for me. I've thought about it I looked at the chart again and thought some more before this meeting, and I still think we should use the panels and rather than the state bar court, and also the 3-person panel, not the well, I take that back. Anyway, I still think we should not use the state bar court. I do remember that somebody at the last meeting, I think, it was a member of the, anyway, somebody brought up, well, how, that seems counterintuitive that that starting a new system would cost more, would cost less than using an existing system. But I think it was just that we hadn't presented maybe clearly enough or enough times the analysis about why it would be less expensive, why a new system would be less expensive. So maybe we've got to make that clearer for the other members of the working group and the public.
And I agree with Ira, and nothing really changed my decision either to move it to state court, state bar court. I think this is a little bit different, and I do think the value of having, you know, the individual within that profession and a public member would be beneficial. And again, I'm not wedded to an adjudicator or the hearing panel, but I do think it should be separated from the state bar court.
I am curious at what other states are doing. We know what Canada is doing, and they have a panel. But what about Arizona, Minnesota, and some of these other states?
So first I'm going to ask Linda, are you pulling this up? Because I don't see it.
I am sharing it. You can't see it? I wonder why that is. Let me try again, because from my perspective, it looks like it's being shared. Let me try one more time. Are you able to see it now?
Yes.
Yes.
Okay. All right.
Okay.
Sorry.
And then to answer Sharon's other question, in the charts that we have outlining how the other programs are doing it, and I know you can't really look for it right now, Linda, but did we, I don't recall this section on discipline. Washington, you heard from, this group heard from Washington extensively. And in fact, that program, maybe Kim or Ira, you want to speak to. I think we took a lot of input from them. Utah is a very small program, and Arizona's, I can't recall what they're planning to do. But Kim or Ira, do you want to speak to Washington?
So Washington, I think, is where we really got the idea of the panel, but they were using a voluntary panel, and then they have now since, originally, right? And now they have since changed, though, their outline. I'd have to pull it up here and look at it as well, but I know they did have the panel model, and that's where we got it. But again, it was volunteers that did it, and we had concerns about that.
And I think you said in this memo, Kim and Ira, that, I'm sorry, my other phone is ringing, so ignore that. You said that Washington was developing a new structure, the new decision-making structure, and that it was out for public comment. Do you know if that has concluded and or what they have decided?
No.
No.
Yeah, no.
But I believe that their original structure was separate and apart from their attorney discipline structure. And their modifications bring them all, and they have another licensee, which I believe is the realtor licensee. And so this change brings everybody under the same model, but they do not have a state bar court model. They have a hearing model, a panel model.
Yeah, that's right. They did say that in their initial discipline program, it resulted in 3 different programs, and they thought that was not workable.
So Linda, do you know off the top of your head, in all the work you've done looking at other states, like what's planned in Arizona, did we include the discipline system?
We did not.
Okay. So that's something we can do. So Sharon, this is up on the screen.
Very helpful. Thank you.
Another threshold issue is this board that you have in the box called hearings and settlement conferences. Have you discussed where this board would come from? Who would appoint members of this board? How many people it would be? And would they be the ones who appoint the 3-person hearing panel? Or how would that all work? Or did you not get there?
We had some discussion, but I believe this is going to be one of our agenda items for our December meeting for the full working group to talk about the overall board for the program, because it's coming up in each of the subcommittees in different ways. But Kim, I know you have some thoughts here. So do you want to kind of share with Julie and Sharon?
Yeah, absolutely. And I was just thinking of it from the perspective of very similar to our boards and bureaus, where you have a board made up of the licensees, public members, very similar to some of our boards that we have as licensing individuals, almost the same thing, that they would then over review that decision and make sure that it is appropriate according to, I can't remember, Greg, there's a different word for disciplinary guidelines. What I would say is disciplinary guidelines, but you guys call them something different. But reviewing it to make sure that based upon the events that happen, that it is the appropriate penalty for those individuals. And then, and the real reason for that is because then you have individuals within that profession who are making the decision, as well as consumers, again, public members, just kind of having that mix to make sure that consumer protection is at the heart of what they're doing.
Sharon and Julie, do you have thoughts on this structure versus the state bar court structure, which would really just be after the blue boxes, it would go to state bar court?
Do you mean use of panels versus use of state bar court?
Mm-hmm.
Well, clearly the use of panels is a lot less expensive for the bar and the licensee, probably. Do you have cost recovery, Leah, at the bar? I forget. Cost recovery, most of the Department of Consumer Affairs boards have something called cost recovery, where they can actually charge the licensee who is the subject of the disciplinary matter part of the costs of investigation.
We do.
Prosecution up to a certain stage.
We do.
Okay. It has the effect of imposing on the wrongdoer some of the costs of the discipline process, as opposed to spreading those out among the entire licensee population.
Mm-hmm.
It's not universal, but it was challenged constitutionally, and it was upheld.
Discipline orders imposed by the Supreme Court do always include an order for costs.
Oh, okay.
But that's only, I think if there's discipline is not imposed, I don't think there's any way to recover costs.
Right.
I also wonder how realistic it is that the paraprofessional who's disciplined will be able to, the payment can be obtained, collected from the disciplined paraprofessional.
And that is an issue with disciplined attorneys. So attorneys who are disciplined, who short of disbarment, in order to be, if they're suspended or if they are disbarred and later seek reinstatement, they are required to reimburse and pay those costs. But for people who are suspended or disbarred and never seek reinstatement, then our efforts to collect those costs are not that successful.
Yeah, and the lawyers are probably have more income and assets than the paraprofessionals will.
Right. but even so, we're not very successful in collecting those costs, the reimbursements.
And couldn't we take this from a bond? And I know that we sort of discussed this, the idea of a bond came up.
I think the information we've gotten about bonds is that as they currently are written, they don't cover wrongdoing, they don't cover discipline.
Mm.
Well, the main information, the hot off the press information, but I encourage you to join the regulations subcommittee for its next meeting, because they'll be hearing from a bond surety or bond agent, is that to make a claim against the bond, you've got to have a judgment, civil court judgment.
Oh,
And the other thing is with the bond, I don't know that the state bar would be a party to the bond. So a bond is sort of a three-way agreement between the person who's hiring the licensee, the bond, the surety company, and the licensee. The state bar would not be a party to that bond.
well, I think the bond could be written in favor. Well, I don't know, but the bonds are written in favor of whoever they're supposed to benefit, and it can be the injured parties, but in theory, I suppose it could be in favor of the state bar too, but I guess the bond expert will talk about that at the next meeting of that committee. That's
And currently with the current structure for attorneys, is, I guess, like getting back the cost of adjudication, does that come after the victims get restitution?
No, I don't believe that kind of hierarchy is in place in terms of collections. I don't know if you know, Linda, meaning if someone owes those costs and reimbursement to the client security fund, which one comes first in terms of collections? If in fact the state bar is the only collecting entity, meaning there's no judgment, it's just the state bar's withholding the suspended licensing fees. If the state bar receives payment, where it applies that payment first versus second, I don't know.
Well, that's interesting. I think we ought to, in our system, ought to make the victim a priority over the state bar. No.
Yeah,
I would agree with that.
It may be the case. I just don't know. I don't know.
And the state bar isn't collecting on behalf of the victim. So we're not really touching those funds. The state bar is seeking reimbursement of payments that have been made by from the client security fund,
Right,
as well as reimbursement of the discipline costs. The state bar is not pursuing attorneys for restitution owed to their victims.
Yeah, thanks for clarifying, Linda. So the concept is not applicable because we don't collect funds and then disperse them to a victim. The victim might have had a disbursement from the client security fund.
Oh, but there still could be in the system we create, there could be stated in the law a priority of liens, if you will. That's what I mean. A priority of liens. In other words, the victim is prior to the state bar in collecting.
Yeah, I think that my concern is really just about the victims and making sure that there is a seamless system that tries to make them as whole as possible without having them have to hire an attorney to sue.
That's being addressed in the regulation committee.
Okay.
But, yeah, and I think those concerns are shared.
Okay.
Right now, they're looking at the kind of the equivalent of the client security fund, mandatory malpractice insurance, and a bond. So they're all sort of working together. We're just learning more about the bonds in particular, because right now the state bar doesn't have any bond requirement.
But very often we do include within the orders from the court, an order of restitution if we're disbarring or suspending somebody and they've retained, for example, retained legal fees that they did, unearned legal fees or whatnot. The other thing I would just add, I mean, the costs are awarded under section 6086.10 of the Business and Profession Code, and that is enforceable as a money judgment. But I don't think that helps you with the bond, because as I think Linda pointed out, it sounds like the three parties to the bond do not include the state bar.
And the state bar is so it's enforceable as a money judgment. And Linda, with the statutory change now, that can be sent directly to the Franchise Tax Board, Tax Intercept, without going to translate it into a civil judgment.
That will be beginning in 2021.
Okay. Because the state bar had not been routinely doing that next step of turning those into a civil judgment, because it's a lot of work for not much return.
But now they're going to be the equivalent, the same thing as the same.
Yeah, the Supreme Court order itself will be accepted by Tax Intercept.
Well, no, that's already been in place. The change
so-
that's going into effect is for the non-court ordered CSF payments. Will
Okay.
be able to be sent to CSF.
So so this group though could, same as like State Bar, they could actually, part of their order, they could order some type of client restitution as well though, right?
I don't see why not.
How do victims in the state bar system collect their restitution? Is there any way other than hiring a lawyer to sue on it?
Well, so that's something, another statutory change that's going into effect in January is making those restitution orders collectible as a money judgment. So that you don't have to do a full lawsuit, you have a judgment and it's just a matter of enforcing it.
Well, that's really a lot hard work though, you know, enforcing judgments. But I guess it's up to the victim to get a lawyer to do it for them.
Or a paraprofessional, hopefully.
Yeah,
to enforce those judgments.
maybe.
No, but we proposed a couple of years ago a set of statutory changes that would have really changed the process, where licensees would make restitution payments to the state bar and the state bar would pay victims directly, instead of having it be outside of the state bar, but that was rejected. So there, outside of that, there are attorneys right now who voluntarily do make their restitution payments. So it does happen.
Right.
Probably a small percentage, right?
Well, those that are on probation and they have the opportunity to get their license back pending satisfaction.
Yeah. Might be a large percentage, huh?
Yeah.
Well, we don't have a large percentage of successful completion of probation, unfortunately.
Oh.
And for the most part, attorneys who are disbarred don't pay anything that's over anyone.
That's why
It's
they.
not a surprise.
But we're working on chasing that down.
So let's kind of circle back and see where we are. I think we're sticking with this model. On costs, there's some additional work that I'm going to do to kind of refine this analysis, estimate the number of cases that would actually make their way to state bar court. I want to do that even though we're proposing this model. I think it's important there's integrity in the fiscal analysis. Add stipends for the panel members and figure out if I can like further refine what that mix of 20 cases, what it might look like in terms of what stage procedurally they would close, which relates to how many of them would go to state bar court, or presumably how many of them might go up to the appellate level. We're going to get information about other states aside from Washington, how they are handling the discipline of their paraprofessionals in terms of a new structure, part of the attorney structure. and regardless of what that structure is, because of course we're the only state with a full-on court system. So we'll get that information. On UPL, I think we have legal work to do to see, would there in fact need to be statutory changes or other changes to accommodate this new type of UPL. And if you all want to hear from someone from our UPL unit and maybe someone from the DA's office, that's something that we can do. Could we talk a little bit about mandatory fee arbitration? Because that came up. I think there's agreement that we would want to include that in our process. And so then this chart needs to change to so indicate. Is that right?
Yeah, for me.
Yeah,
Okay.
we talked about it earlier in the process, right?
Yeah. I think we can talk to the mandatory fee arbitration folks and figure out exactly where that would fit. And I'm assuming our recommendation would be that this would be incorporated into local bar associations' existing mandatory fee arbitration programs, as opposed to recommending establishment of a new standalone mandatory fee arbitration program. And local bars do charge fees for those programs, so they would be assessed to the paraprofessional.
Oh, but the state bar has no expense in that, no significant expense. Is that right?
We have some. The state bar promulgates rules. The state bar does approve programs. I believe if there are certain appeals come up to the state bar, or counties that do not have a program, the state bar handles that program. So we'll have to dig into that a little bit more.
But a mandatory fee arbitration order is not considered discipline, right? Or is it?
I think that if it's not paid, that's grounds for discipline, someone who doesn't comply with a mandatory fee arbitration order. But the order itself is not considered discipline.
Okay.
And there was the suggestion about that including the paraprofessional program in the mandatory fee arbitration program would help to reduce the number of discipline cases, because many of the complaints that come in really are at their core complaints about fee disputes.
Mm-hmm.
So it's almost like it's a diversion from the discipline system.
So from our original list, Linda, is there anything we haven't touched on today?
So there still is this issue about, can you see this? I brought the PowerPoint slide back on.
No.
Hold on a second. Let's see if this is going to work. You able to see it now?
Mm-hmm.
So one of them was whether the non-disciplinary remedies would be part of the public record. There was discussion about that at the meeting on October 29th.
Should we discuss that now? I guess so, huh? I was thinking about this before the meeting too. I think so. I think it should be part of the public record. And partly, it's always bothered me that that there's so much the non-disciplinary stuff against lawyers, or even disciplinary actions at the lower levels are not part of the public record. And I think they ought to be.
I totally agree with you, Ira. I'm all about, consumer education, and I would like consumers to be able to look that up. I know that with attorneys, oftentimes they do this over a series of years, and sometimes they get like a slap on the wrist. And I think with paraprofessionals, it could be a whole pattern of behavior that doesn't rise to the level, but as a consumer, you still want to know that.
I also agree that they should be public, the citation and fines. What other non-disciplinary remedies would there be?
Well, I think we have a box called diversion, and I'm not sure what that is. But if we were wanting to recommend, for example, or mandate completion of a course, like right now, sometimes attorneys have to take client trust accounting. There's certain courses they have to take. So that might be one.
Okay.
Office management, there might be that kind of directive that would be non-disciplinary.
So, and I think that if diversions like that, like requirement to take courses, if those become public, that reduces the incentive for people to participate in diversion. So, I mean, that's something to consider, and that might lead to more cases that have to be pursued all the way through hearing.
Wow, this is a hard one for me. I'm thinking of diversion in misdemeanors, regular, not lawyers, or it's just regular misdemeanors, where and I don't know whether there's a public record of the charge and the decision to allow diversion and the outcome of the diversion in the criminal context. I think there is some public record of it. I think that the filing of the criminal complaint is probably still a matter of public record, and I don't know how much more is.
And I think that's the same with the state, in the state bar with discipline. Cases become public as soon as a notice of disciplinary charges is filed. If a case is resolved prior to that point, it doesn't become public, and the fact even that a complaint was received is not public.
Oh,
But once the charges are filed, it's public.
I have a feeling that, I don't know, it'd be good to know that in the criminal system, the criminal complaint doesn't disappear from the record as a result of diversion. It might, but I don't know.
Does the state bar not disclose on its website disciplinary stipulations?
Yes.
You
The
do.
stipulation is formally filed. The state bar court has to approve the
Right.
stipulation, and it has to be approved by the Supreme Court. But cases are resolved without stipulation or a notice of disciplinary charges do not become public.
So for the boards under DCA, the citation and fines are public, I think, for almost all of them. Julie, I think, right? I think it's every one of them. I want to say that cite and fine is public. But if they were to enter into like a diversion program, if it was truly just diversion program, for most of for like substance or alcohol abuse, most of the boards, if they stop it before it goes to discipline, that is not something that's public. And we don't really do any other type of non-disciplinary remedy. If they took a course or something and maybe the citation was withdrawn, that wouldn't be public as long as the citation was withdrawn. But if they uphold the citation, then that would be public. But some of those other non-disciplinary, like diversion, it's not public.
Yeah, and the statute that Kim is talking about is Business and Professions Code Section 125.9. That sets up a citation and fine system for all boards and bureaus within the Department of Consumer Affairs. And each board or bureau that wants to issue citations and fines has to adopt regulations that would govern that whole process. And under that statute, the regulations have to include certain things, like how the licensee gets notified that they're being considered for citation and fine, what has to be included in the notice. If they don't like the issuance of the citation and fine, who can they appeal to and how and when? So it's all in that statute 125.9. And Kim, what you're saying, what you said the other day or October, is that the State Bar does not have a citation fine system?
No, that's what Leah said, right? There's no
Yeah.
citation and fine system currently.
Okay. But you have lower level sanctions, like, right, like a private letter of reproval, letter of private reproval, letter of public reproval, you have all that stuff?
Yes, and private reprovals, there are some instances in which private reprovals are part of the public record.
Mm-hmm.
But for the most part, they're not, and public reprovals always are. And I think the situations when a private reproval does become part of the public record is if that's the end resolution of a case where a notice of disciplinary charges was filed. So again, once that's filed, then everything prospectively is part of the public record. So
Right.
that's filed, and then it resolves with a private reproval, then it becomes public.
And so what you were saying before, Linda, is that once the NDC is filed, anything that results from that, including a stipulated, disciplinary decision, gets posted on the State Bar's website. It is
Right.
a matter of public record. If it's resolved prior to the filing of the NDC, like just through some negotiation and there is no discipline, none of that pre-NDC information is going to be posted on the bar's website.
With the exception that if there's a stipulation without an NDC being filed, which sometimes happens, there's an
Mhm.
agreement, that stipulation is ultimately filed. It's just
Okay.
not, it just might take longer because it's not going to show up until everything is resolved. So it's just more a matter of timing of when things become part of the public record.
Just found an answer to my question about whether in the criminal system, diversion results in wiping out the record of the charges, and it does. I'm looking at I just found it on a lawyer's website. It looks reliable. It says if the defendant successfully completes the diversion program, the charges are dropped and sealed. If not, it goes back to the criminal system. Penal Code Section 1000. Must be a long section.
I think there's a tremendous tension. I've observed this with the attorney discipline system, that it is not focused on rehabilitation, right? The criminal system in our country and certainly in our state has really moved and changed its focus. And its focus is very much on rehabilitating and reintegrating in society. And so like record clearance, all of these things, ban the box in the employment forms, it's all designed to give people an opportunity to successfully reintegrate. We don't have that on the attorney discipline side. And so like the push to make things public, it makes a lot of sense. And I'm sure it's protective of the public, but it is counter to the trends that you see in the criminal justice world. So I don't know, Ira, if it's a good analogy or not, because the systems are designed really differently at this point.
Yeah, I think it's probably not. That was interesting what you said, Leah. I hadn't thought of that.
So just a round robin on the question of whether or not informal discipline, I can't remember the nomenclature. Basically, is there going to be such a thing as non-public discipline or things that fall short of discipline? Non-public intervention is there going to be such a thing as non-public intervention in the paraprofessional discipline system? Or is everything going to be public, even referral to a course?
Hmm. Well, if a paraprofessional is charged with something or other and wins the hearing and it prevails, there ought to be a way to seal that, shouldn't there? Make it non-public. The whole thing, even from the beginning.
And the reason I think cite and fine should be public, I'm kind of torn on some of the other types. If you just have an individual do a course, I don't know if that needs to be public, but definitely on the cite and fine, the reason I think it needs to be public is because there was a violation found. It's not like, you're just kind of settling out, but you couldn't prove a case enough to take it to discipline. Cite and fine is like a way, it's a lower minor violation where you don't think disciplinary action is warranted, but there's still a violation of the law. And so I think that's why it's important for the public to know that.
Okay.
I think that I agree with Kimberly, and I think that that's striking a balance between rehabilitation and just consumer knowledge, education, knowing what they're getting into.
Okay.
And I think if you
As
look,
well, but that assumes you get citation and fine authority.
Yeah.
Yeah.
and I think if you look at it from the perspective too of what do you want the public to know? So if there was a violation of the law, if there was something that would put them in, that it's something that would help them make an informed decision, then that's something they should know about. As to where an individual taking an education course, being required to take an education course, I'm not really sure if that one, if it's not attached to a citation and fine or to some type of, settlement, if that's something that would need to be, the public would have to know that. I'm kind of torn on that one.
Okay, well, I think we can draft it up reflecting that distinction for now. You guys can keep thinking about it.
Can I throw out one more thing?
Yeah.
And correct me if I'm wrong. Over at the medical board, most disciplinary actions are now posted on the board's website, on the physician's profile, indefinitely. There used to be a 10-year limitation, and I believe that was removed am I wrong, Kim?
It depends on the level. So like a public letter of reprimand or a public reprimand, those still get taken away in 10 years.
Okay.
But probation, revocation, suspensions attached to a disciplinary order, those stay there indefinitely. Cite and fines only stay there for 3 years.
3 years. Okay, that's what I was getting at, is that there's a way to make it public for a while.
Yeah.
And then remove it from the bar's website.
Yeah, that could be another option.
Yeah.
And I know by making them public, it is a deterrent to behavior because they really don't want anything posted. So if it's something that even could reach to the level of cite and fine, they really try not to do it. So it is kind of a deterrent to violations.
Okay, as we head towards 12:30, just want to make sure you've heard from me everything that you're kind of expecting to happen before the next meeting, or is there something else?
I'd like to bring up one unsettled issue that, which is in the chart that we've created. Well, that's been created. in the hearings and appeals, there's two different options. One option is to have a 3-person hearing panel. Another option is to have a staff adjudicator. And that those options exist for the hearing, the initial hearing, and the option exists for appeals of the decision in the hearing. I was thinking about this before our meeting today, and I think that it ought to be a single adjudicator for the hearing and 3 people, a 3-person panel for the appeal. Mainly because that's such a common scheme in a lot of adjudicatory systems. And of course, having one person one person deciding the initial hearing is more efficient and less expensive.
Are you able to see that now on the screen?
Yeah, so you're saying, Ira, no panel for the hearing level and a panel for the appellate level.
Yes.
Okay.
Could you say that one more time, Ira? I'm sorry. So,
At that hearing level, the one immediately above the blue boxes,
yeah.
I'm advocating, not that strongly, but I'm advocating having option 2 to the right, the staff adjudicator be the person who decides, not the 3-person panel on the left. But then on the appeal going above that, I'm advocating having the hearing panel, the 3-person panel on the left.
And Ira, is your thought for having option 2 in the initial hearing just costs and efficiency?
Yes. And bearing in mind that it's not just cost for the state bar, but oh no, wait a minute. I was going to say it's cost for the paraprofessional who's undergoing charges too, but no, it wouldn't make any difference for that. I don't think. I can't see how it would.
Would that staff adjudicator on the hearings and settlements box phase, would that person be an attorney?
Yeah, we discussed this last time. It's not clear. I thought in my mind last time, I thought, yeah, that's an attorney, but then I was corrected and said, not necessarily. I think it ought to be.
Could it be a paraprofessional?
Could.
I mean, the decision makers at most Department of Consumer Affairs boards are board members mostly. There's one agency that doesn't follow that rule, Contractors Board, but they're board members who are usually in majority licensees. And that often raises bias concerns in all kinds of directions. Either that the licensee members of the board are being overly harsh on their fellow licensee, or they're being unduly lenient on their fellow licensee.
I think it ought to.
Go ahead.
I really think it ought to be a lawyer. It ought to be somebody who's very familiar with the ideas and the processes of what's reliable evidence, how to proceed in a formal adjudicatory hearing. I mean, I'd love it to be a administrative law judge, but apparently that's pretty expensive.
So it's 12:30. I'm going to suggest we come back to this at the next meeting and maybe folks can think about it. And what, do you know when that meeting is scheduled, Linda?
Yes, that meeting is scheduled for December 1st.
Okay. All right, everyone, thank you.
Leah, one thing, you mentioned that the regulatory subgroup is meeting to talk about, when is that meeting? Do you know off the top of your head?
That's also on December 1st.
Oh,
I
okay.
have 3 meetings on December 1st.
Okay.
But not at the same times, I think.
No, not at the same time because I'm staffing all of
All right.
them. But they're pretty much back to back, I think, on December 1st. They are all posted. All of the meetings through December 1st are posted to the website. And you should have received notices. Everyone, I think, is on the list to receive notifications of meetings. Everyone on our working group.
I'm sure I did. I've been out of the loop.
Sure,
Yeah.
and I'm happy to resend them, or you can go and look. It's up to you. I don't know if you would prefer to get more emails in your inbox, or you prefer to go to the website and look for it.
Since we're within 10 days, it's pretty, they're pretty easy to find on the website.
Yes.
Yeah. And thank you for coordinating all of this, Linda. It's a lot to coordinate.
Yeah, thank you.
Okay.
And Leah,
Thank you.
All right, have a happy Thanksgiving, everyone.
too.
Thank
You
you.
too.
You too.